Let's go to People versus Hatton. That is number 157. Counselor, do you want any rebuttal time?
Yes, 2 minutes, please, Your Honor.
2 minutes. Go ahead, Counselor.
May it please the Court, my name is Leonard Jobler for the appellant on this appeal by the people. The accusatory instrument in this case is facially sufficient with respect to the count of forcible touching to which the defendant entered a plea of guilty, because that count satisfies the facial sufficiency standard applicable to an information. In particular, the factual allegations which stated that the defendant smacked the complainant on the buttocks and that his act of doing so caused her to become alarmed provided reasonable cause to believe.
Talk to us about inference. What about inference?
Yes, Your Honor. The appellate term held that the factual allegations are insufficient to support the elements of intent required by the statute.
So can we infer it? Can we infer it?
Yes, Your Honor. In
How
fact,
so?
Ordinarily, intent needs to be inferred from the acts of the defendant and the circumstances surrounding the acts of the defendant, and it would be the exceptional case where there's an explicit statement of intent.
But what were the surrounding acts that were alleged here?
The essence of the act, Your Honor, was
the surrounding circumstances.
Yes. Well, starting with the act itself, it's an act of forcible touching of an intimate part of the complainant's body, and the allegation also is that this touching by force was done without the consent of the complainant, because the allegation is that this touching caused the complainant to become alarmed. And in general, certainly for prima facie purposes, allegations that a person is subjected to a touching of...
What does the intent have to be in this case?
Your Honor, under the statute that defines the forcible touching offense, the intent needs to be that the defendant is performing the act for no legitimate purpose, and either for the purpose of degrading or abusing the complainant or for the purpose of the actor's sexual gratification.
So how do we know that from what we have?
I think it's inherent in the act, the reasonable inference from the act that the defendant is alleged to have approached the complainant on the street, subjected her to a forcible touching of an intimate part of her body without her consent.
So we get that. How do you get to the next step? It's part and parcel of those allegations?
Well, just in general, the intent has to be inferred from the act and the surrounding circumstances.
So you're saying it's inherent that someone standing on a street corner and a stranger comes up and hits them in an intimate part of their body like they're behind, that you can infer from that there was an intent to embarrass or alarm or to satisfy the actor's sexual gratification?
Yes, Your Honor, and certainly this is at the pleading stage. So this is the people are not expected to try their case in the accusatory instrument.
We don't need any other information, like there was a discussion or there was no discussion, nothing was said between the two parties, either when the person came up and smacked this person on the behind, didn't have to say anything, didn't have to make any kind of comment or statement, and we can just infer that the act itself shows intent.
Yes, Your Honor. Certainly if there was either a contemporaneous statement by the defendant at the time or there was an admission subsequently regarding what his intent was, that would be relevant, but it's not.
That does not have to be in the information, you're saying? Correct.
So you're saying it's an affirmative defense?
Well, it's an element that the people have to prove beyond a reasonable doubt.
Well, then why are you saying, if he wants to say that he didn't do it for sexual gratification? That way you're suggesting that you don't have that burden, he or she does.
Oh, no, Your Honor. Quite the contrary, saying that in the event the defendant had made a statement indicative that he acted with the intent required by the statute, that would certainly be an additional fact that could be alleged.
How does this differ from, like, the Jones case? How does it differ from the Jones case?
I'm not sure which case Your Honor is referring to. Jones?
Yeah, People versus Jones. When you're standing in the street, and as Bishop, we said, there's no There's no showing of intent, not a reasonable inference. You familiar with that case?
Was that the disorderly conduct case,
Yes.
Your Honor? Yes. Well, it's a question of, these are case by case about what are the facts alleged, what is the conduct of the defendant.
But there we didn't find, intent, right?
Yes, Your Honor, but that was not a forcible touching statute. There was no allegation of a touching of the private parts of the person's body.
So the touching, coming back full circle, so the touching is all there needs to be?
Well, it's not just a touching. It's
Or
a
the
touching.
allegation of touching, yeah.
Yes, but it's an allegation of a touching of an intimate part of
Yes.
the person's body with the use of force, which is an element that's necessary for this particular offense. It was alleged that it caused the complainant to become alarmed, which supports the inference that there was a lack of consent. There was the allegation that the defendant approached the complainant on the street, which supports the inference that it was the defendant who initiated this encounter, and that in terms of whether there was a legitimate purpose, that certainly tends to refute what would seem to be the unlikely inference in any event of the possibility of self-defense.
So to clarify, so in that conjunctive of the statute, purpose of degrading or abusing the victim or the purpose of gratifying the defendant's sexual desire, which one applied here?
Either could apply, Your Honor.
Well, how does he know which one to defend against?
He needs to defend against both because the statute provides in the disjunctive, but that means the people can prove either
What if it
one.
listed five bases? He still wouldn't have to know which one or ones you're depending on?
No, Your Honor, any more than in an assault prosecution where physical injury is defined as either impairment of physical condition or substantial pain, the jury at trial would need to be unanimous that there was physical injury. But even at trial, the jury wouldn't have to be unanimous on that subsidiary component of the definition.
Well, what I'm wondering is, would it have been facially sufficient or more effective if you had said, being a stranger to the complainant, he completed these acts? It would seem to me, however, by articulating that the complainant was alarmed, that should satisfy that element of the intent to clarify that, because, of course, there can be intimate touching in public, and that takes place all the time, and there can be other motivations. I mean, this person, as I understand it, offered a psychosis argument and was sent for some form of mental health counseling, wasn't he?
Yes, Your Honor.
Yeah, I think serendipity, I don't know what it is, but it sounded, going through the record, and it seemed there could be others. I mean, could be a college student who's just an idiotic bore who's doing stupid things like this. So it seems that there would have to be, and it does appear to be in the complaint, but would you agree that there has to be some element in there that shows either from the complainant reacting to the touching by saying it was objected to, or by the fact that there was no relationship at all, like they were being a stranger, to establish as element of intent?
Yes. Well, first, certainly just the fact of a touching would not be sufficient, and even a forcible touching generally would not be sufficient.
I'm not sure about that. Forcible, it may be, but anyway, go ahead. Yeah.
If the theory is that it's possible for someone to consent to the forcible touching, but the point is there's more than that, and if it's a forcible touching without the consent of the complainant, in general that's going to be enough. Here, certainly if they were strangers, that's an additional fact that could have been alleged, but if the question is whether it's legally necessary to make a prima facie case, it's not. And in this case, even while there wasn't an explicit statement that they were strangers, the fact that the accusatory incident alleged two different acts against two different complainants a week apart that were essentially the same, approaching someone on the street and engaging in the same act, itself supports the inference that these were not acquaintances of the defendant.
Thanks, guys. You'll have your rebuttal. Let's hear from your adversary.
May it please the Court, my name is Arthur Hopkirk. I represent Frankie Hatton.
Why isn't this a reasonable inference in this case, counsel?
Because the mere facts, and this is all we have in this case, of the complainant approaching somebody on the street and smacking her about the buttocks addresses the elements of touching and force, but it says nothing, for example, about the for no legitimate purpose element of the crime.
What about the complainant's statement that she was alarmed or annoyed by this?
That
doesn't raise an inference that this was without consent and that there was an intent to embarrass or alarm her?
Your Honor, it certainly goes, as the appellate term found, to the lack of consent element, but it doesn't go to the for no legitimate purpose argument element or for the sexual gratification or degrade or abuse elements. The people's argument in...
But why not? Why doesn't it go to that?
Because, well, first of all, you only get to the question of whether you can draw inferences if there are some facts alleged going to a particular element. There aren't any facts alleged here going to those elements. And in fact, the people, as one of the questions was suggesting about affirmative defenses, for whatever reason, the legislature apparently, in putting in a no legitimate purpose element to the statute, contemplated that there might be some circumstances in which there would be a legitimate purpose, and thus, consistent with the legislative scheme, the people need to allege some facts. They allege no facts, and I want to make it
What
very...
would be an example of facts that you think could have been alleged and would have been sufficient here?
Certainly, Your Honor. And I want to make clear, it doesn't have to be many facts, but some facts. And I would suggest that an example that might have done the trick here is if the information had pleaded that there had been no prior interaction and no prior relationship between Mr. Hatton and the complainant. That might have been enough, but we don't even have that here.
How does that get to no legitimate purpose?
Well, there we get back to the district attorney's argument that we don't have to have allegations of the sort which would be sufficient at a trial, but at least with those you start to get towards some support and drawing some probable inferences there, whereas with no facts you don't even get to that point.
So give me an example of a fact in this setting that would indicate either a no legitimate or a legitimate purpose.
Well, a legitimate purpose, as we argue in our brief, would be self-defense. A no legitimate purpose would be many other things, obviously the sexual gratification. And I think contrasting the facts of this case with the Guaman case is useful. Guaman was the forcible touching case that was up here about a year and a half ago. And there you have a defendant who was alleged to have exposed himself and had been rubbing up to the buttocks of somebody in the subway with an exposed penis and so forth. And there clearly, I think under those facts alone you can infer.
So there the legitimacy of his purpose was unquestioned.
It clearly was illegitimate.
I would say so.
Yes,
But here it's different.
That's correct, Your Honor. And I think that's a key point here is you have to look at context and circumstances.
Speaking of context, counsel, there's another allegation that this same defendant came up to a second woman and smacked her on the buttocks as well. So are you, and they were not together, they were two different incidents. So would you not be able to, from that context, infer that there's no legitimate purpose in smacking 2 or 3, or I think there were 6 women in this instance. This defendant smacked 6 different women on the buttocks. as they were standing in public on the street. So would that context suggest to you that there was no legitimate purpose in what he did, or perhaps that he was doing that to satisfy his own sexual gratification?
No, Your Honor, and my answer to that has, I think, three parts. First of all, the forcible touching counts on those other incidents suffer from the same defects as the one they pled guilty to, and one can't cure a jurisdictionally deficient count by drafting multiple counts.
We are to then, according to you, we would then be, you would be suggesting that these were all friends of his or acquaintances, and he just happened to see them on the street and want to come up and smack them on the buttocks, and that's it?
No, Your Honor. Let me, I think it's useful to look at it. Let's assume for the purposes of argument that when you have a pattern of several incidents of this sort, that perhaps some of these were not for legitimate purposes. Let's just assume that for purposes of argument. That doesn't cure the problem of, without providing some facts as to the context of these, you can't tell whether these involve similar MOs or completely different situations that led to them.
I think for your purposes, we should assume they're all the same. Really, it comes down to what Judge Lippman brought up initially, which is whether or not intent can be inferred from the act. There clearly was a touching here. Since it's referred to as smacking, we'll assume that it was a forcible touching. So therefore, can it be inferred directly from the act? And either it can or it cannot. And it's whether or not that logical inference can be left, because there isn't really anything else to connect it.
Yes, Your Honor, I'd agree with that.
Okay, so then
It's
return
quite,
to the
I'm sorry, Judge.
No, finish your thought.
It's quite common in sex cases, in sex sexual offenses for almost always is the intent inferred from the act.
That is often true, yes, Your Honor. However, that still doesn't excuse providing no facts relating to the context, however minimal here. As I say, the people would like to write some of the elements out of the statute.
Do you have an opinion? He was charged with, I think, 6 charges, 12 charges, a lot of them. Forcible touching, sexual abuse in the 3rd degree, and harassment in the 2nd degree with respect to a number of people. When he pled guilty, the court said, walked him through and said, and this was done for the purposes of abusing that person or to gratify your sexual desire. Is that correct? And he says yes. And so the plea is accepted. And I understand you don't have to preserve jurisdictional stuff, but had the people charged him with harassment, you would not have the arguments that you have today, and yet by pleading guilty, you've gotten rid of all of those charges, all the charges that may have not had a jurisdictional impediment such as you're raising today. Do you have a thought on how these pleas are taken and what's going on here?
Well, I guess the answer to that is, among other things, on the harassment charge, I believe that was the violation. The people, I won't speak for them, I'm suspecting they would answer that they want a plea to a crime, not to a violation. But beyond that, I think I'd be just speculating.
Counsel, let me ask you about the same question I asked the people, the second part of the statute, the purpose of degrading or abusing the victim or the purpose of gratifying the defendant's sexual desire. Did they have to make clear in the instrument which of those purposes?
It certainly would.
Drove the defendant?
Excuse me?
Which of those purposes motivated the defendant? Did they have to explain which one?
I think they need to. They can plead in the alternative, but they need to provide some facts supporting whatever theories they're going to rely on, I guess would be my answer to that.
Counsel, you mentioned, I'm just getting back to the inference question again. You mentioned in your brief that if the instrument should have said something regarding whether there had been some words exchanged between the victim and the actor, or blows, or some sort of hitting. And if the instrument, suppose the instrument had said that none of these things occurred, would you then agree that you could infer from the instrument that the purpose of hitting this person on the buttocks was either to intimidate or embarrass or annoy, or to satisfy the actor's sexual desire or gratification?
Just so I'm sure I understand the question, my understanding is that Your Honor's asking if they had pled facts of there was no conversation between the complainant, there was no physical altercation between the complainant, etc. If they had pled those things, could you infer? I think certainly for pleading purposes as opposed to trial conviction purposes, yes, you could infer, but none of that happened. And I'm not even sure, as I said in response to one of the earlier questions, you probably don't even need quite as much as I was just suggesting in response to your question. As I said in response, I believe, to Judge Stein's question, probably it would have been enough if you had pled something along the lines of just that there had been no prior interaction or no prior relationship between Mr. Hatton and the complainant, but there wasn't even that. And so for that reason, the accusatory instrument was jurisdictionally deficient, and the order of the appellate term should be affirmed.
Thank you, counsel. Counsel, rebuttal?
Yes, thank you, Your Honor. First, I'd just like to follow up on Judge Rivera's question about the fact that there are two alternative intents offered or that can satisfy the elements of the statute. And another example would be in a burglary case, there has to be proof that the defendant unlawfully entered the premises with intent to commit a crime therein, and there's no requirement that the people, certainly at the pleading stage, specify a particular crime, and even at trial, the people do not have to limit themselves to a particular crime. So as long as the allegation is that the defendant acted with the intent to commit some crime, that's sufficient, and it may be that an accusatory instrument or even the evidence at trial would support inferences of different possible crimes, and even at trial there's no requirement of unanimity that all 12 jurors...
Even if the factual statement doesn't suggest a particular crime? That with the assumption that it suggests a particular crime or several crimes, perhaps.
It might, as long as the evidence would support an inference of an intent to commit a number of different possible crimes. The point is there doesn't have to be unanimity even to support a verdict after trial, and certainly at the accusatory stage it's sufficient.
My question is, how is the defendant on notice to prepare their defense if they don't know what crime you're charging, if they don't know whether or not you're arguing it's sexual gratification or to degrade?
Well,
or both.
The defendant's on notice. The defendant's on notice that if the evidence shows that he acted with either intent, he's guilty of the crime, just as the trespasser who goes into premises is on notice that whether the intent was to commit a larceny or an assault, he's committed the crime and he can be found guilty. Second, with regard to the evidence about the repetition of the act, there doesn't have to be any showing of a similar modus operandi. This isn't being introduced. The evidence of the second event wouldn't be introduced at the trial on the theory of identity. It would be introduced because the repetition of the act by its nature tends to refute an innocent explanation or the inference that there was an innocent explanation for the act itself if there was any ambiguity about the intent underlying the first act. And finally, the standard that applies in determining the facial sufficiency of the accusatory instrument is to give the factual allegations a fair and not overly restrictive reading. And certainly when it comes to the latitude that a trier of fact is given, even at trial, to draw an inference about what's a reasonable inference about the defendant's intent based on the act, that applies in the accusatory instrument as well.
Thanks, counsel. Thank you both. Appreciate it.